Good evening. Thank you for coming tonight. I really appreciate it. Appreciate being here on time so we can get started on time. And I have high expectations for our time together. There are a couple of things that make this really, really important. One is that you would never want to take financial advice from your pastor. Nor would you want to say amen when the pastor admits that. But secondly, it has been our desire. I believe God wants us in leadership to provide you with all the tools that you need across the board to deal with issues in your life. And so we have that opportunity tonight. We have invited someone that many of you, or at least some of you, know and have worked with before. As time has gone on and we have aged, it occurs to me that more than 25 years ago, Mr. Pippin did exactly this for a church I was pastoring in Largo, and he has earned great respect through the years as a man of integrity and a man of wisdom, and we considered an honor that he would come tonight. Let's pray and then just give the floor to Mr. Pippin. Father, thank you for bringing us here. We do believe that not just the biblical things in our life, or not just the spiritual journey we're on, we believe that every part of our life needs to be, and we want it to be, surrendered to you. As we were discovering in our Sunday mornings, there are two keys to life, and one of them is to love you with all of our heart and all of our soul and all of our strength and all of our mind. And that basically, as Paul said, is to offer ourselves, every part of us, as a living sacrifice to you. This, we believe, the journey we're on tonight is a part of that surrender, so help us to open our hearts to you. Thank you for your servant who has come to give us guidance, and let us think clearly, let us receive what he shares, and ask the appropriate questions, and then follow through as you would want us to. Thank you for that. It's an honor for us to be before you and with our new friend. Thank you. In Jesus' name, amen. It is an honor for us to welcome Mr. Joe Pippin, and as I said, many of you know him. So, Joe, the floor is yours.
Thank you so much. Well, it's a great privilege to ever get to be asked to speak in a church, and it's very humble for a pastor to share his platform with me. So what I'm going to talk about tonight is estate planning. I don't really give financial advice. I have a couple of financial advisors that help me with that. But over the years, I've spent most of my time. I didn't start out doing estate planning as an attorney. I did multiple areas. I did just about every area of law you could imagine. I didn't start practicing until I was 35. I had 2 other careers before that, and when I started, I just wanted to learn everything and do everything if I could. And I eventually gravitated to doing primarily estate planning. So today we have 7 other attorneys and 20 office locations, and I have other attorneys who do other areas of law, and I prefer to spend most of my time in estate planning. So what we're going to talk about tonight is what to do with assets. Now, how many of you own assets? All right. So who owns the cattle on 1,000 hills? All right, well, the question is, if God owns the cattle on 1,000 hills, what assets do you own? Or are they just entrusted to you? All right. It's kind of a trick question. You got to watch attorneys. They can ask trick questions all the time. So the reason I like to start my presentation like that is you have a whole different perspective on what to do with it in estate planning if you know you don't own the assets. They've just been entrusted to you to be a good steward of those assets. So therefore, you should be a good steward in your estate planning with what you do with those assets. And that puts a whole different spin on most estate planning talks you'll ever listen to, because most people don't really go to that point. So you don't own it. You're entrusted with them to be a good steward, to be wise with what you do with them. Now let me ask, how many people here have perfect children? If you raised your hand, I'm going to say you're delusional. Liars, I wouldn't go quite that strong. All right, well, the truth is there's only one perfect person here that ever walked the earth. And none of us are perfect, far from perfect. Your pastor is probably not even perfect, I don't think. None of us are. So we all have problems to deal with in our estate planning and being a good steward of our assets and doing the very best for you can with your family. So I'm going to talk about some things that come up in families and why maybe an outright distribution in your will or trust is not the best way to distribute assets. And we'll talk about some things like that. We'll talk about a Christian testimony that you can place in your will. So what I like to do is to go through the 3 options in estate planning. Every one of you have done one of 3 things. So I'm going to talk about what you've done, the pluses and minuses of what you've done, and then the other 2 options and the pluses and minuses of those. So what do you think the most popular option in estate planning is? What do you think most people have chosen to do? Lots of nothings. Any other guesses? Wills. Doing nothing is actually the right answer. Anybody think of anything positive about doing nothing? Any positive thoughts about doing nothing? It's what? I always get cheap and easy. I get you don't make mistakes if you do nothing. No, you might have made a mistake by doing nothing, but one person told me, now I know this was true because they were talking to me. They told me they hadn't died yet, so therefore they hadn't needed any estate planning and so forth. I knew they hadn't died yet because they were talking to me. One person actually said revenge. Those kids haven't done much for me lately, so I'm not going to make it easy for them. That's probably the list of positive, if you consider any of those positive. Are there negative things about not doing any planning? Yes. What would be a negative thing about not doing planning?
The government gets more of your money and lawyers. You know how we think about lawyers.
Yeah. All right. So the government doesn't really get very much of your money if you do nothing. But your estate, you forced the government to make all your decisions for you. For example, if you do nothing, you have something. You have a statutory will. You have a will that the state of Florida made for you. And it would be not like the will you would make for yourself. If you do nothing, then you've allowed the state to appoint your personal representative. Some states call it executor, and Florida's personal representative. So you've worked your whole lifetime, you've accumulated and saved an estate. You've allowed the state to decide where it goes and who's going to be in charge of it. And your statutory will upon death goes through probate. Probate is the proving process of getting assets out of a deceased person's name. So if you've done nothing, or maybe you have an old will from another state, I reviewed one of those today, that would not have been a valid will in Florida. If you have an old will that doesn't qualify for a Florida will, or you've done nothing, the state of Florida makes one for you. You have probate, it's public that you did nothing. That's not being a good evidence of being a good steward, right? Proof that you did nothing by the state making a will for you. So doing nothing results in probate of a statutory will. It's a public record, and the state makes all your decisions with all of your assets instead of you taking the time to do that yourself. All right, so doing nothing, there really aren't any positive things, and there are a bunch of negative things about doing nothing. All right, the second choice is a will. Now, the most common form of estate planning is making a will. How many of you, if you don't mind sharing, have a will that you prepared as your primary document? All right, half of the group at least. The advantages of wills are you did something. That's good, you did something. You're not going to have a statutory will. You have your own will that you had input into preparing. You appointed somebody to be the personal representative. You appointed somebody to be in charge of your choice, and you named a backup. You have a plan of distribution that you developed for your family, taking into consideration what would be best for your family. All those are great things. Are there negative things about wills? Yes, if you have a will, a statutory will, or even a will that you signed, upon death your will goes through what? Probate. Now, how many people would want their will to go through probate? If you raised your hand, you actually chose probate. If you raised your hand that you had a will, or if the state makes a will for you, that will goes through probate. Probate is the only way to get assets out of a deceased person's name. And it's a choice you make when you sign a will as your primary document. Probate is a 3 to 6% fee. It takes 6 months to a year. It's a long, drawn-out process where your heirs or your personal representative that you appointed has to choose an attorney to help them through this process. The attorney fee is and the personal representative fee is 3 to 6%. So if you have just say a $500,000 probate estate, you could have 3 to 6% fees. That's $15,000 to $30,000 in fees to get the assets out of a deceased person's name. Probate takes 6 months to a year. It's a long, drawn-out process. When you die with a will, your will gets filed with the court as a public record. There's no privacy of what you did for your family. No privacy. Your will is a public record. You go buy a book on wills at the library of maybe the wills of famous people. How do they know so much? The will's a public record. Wills get filed. To go to the county records, your next door neighbor died, you want to see what they did in their estate, you can go buy their will at the courthouse. $1 a page. It's a public record. No privacy. So the disadvantages of wills are they go through you've chosen for them to go through probate when you die. It takes 6 months to a year. It's a public record. The positive things are you named a personal representative of your choice and you have a distribution plan of your choice. And you did something, all of that's positive. On the negative side, probate, public record, cost a lot. Also, a will only plans for death. So if you have a will and become incapacitated before death, and that's all you have, guess what? You're going to be declared incompetent and direct to a guardianship process. You really haven't planned for guardianship if all you have is a will. A will too, now if I were to ask how many people here have just given outright, you have 3 children, 3 equal shares to your 3 children, outright. If I asked that, a few of you would raise your hand. And then if I ask, well, are there maybe some special circumstances you should be thinking about in your estate plan? Assuming that we don't have perfect children, are there some special things we could do for children in our estate plan that would help them? And would an outright distribution be harmful sometimes? Let me give you a couple of examples. Some of you may have a child that has an addiction problem. Well, guess what? You give him or her a third of your estate outright. What have you done? You just enabled the addiction. Suppose you said, well, I don't want to enable addiction. I don't want them to have a bunch of money to enjoy their addiction for a period of years after I die. So what I want to do is to give them a monthly amount. Could be a dollar amount. Could be a percentage over a number of years. Let's just say you decide to give them $2,000 a month for as long as their third of their estate lasts. But you put language in there that if their monthly distribution is subject to random and mandatory testing. And if the addiction pops up any time during their distribution period, their distribution gets suspended, but can be used for medical and rehab purposes. So what have you done? You've enabled them, you've motivated them, hopefully, to not have the addiction pop back up. You provided care for them if it does, and you have a long-term continuation pattern of being able to help them after you're gone. Maybe you're the key support system for them, but you're gone. So that they might jump off real quick and jump on their addiction real fast, but then they get a copy of your will. What have you done? You have a plan for them. You have a plan to be a good steward. You have a plan to do the best you can for your family. You don't have a plan to help destroy them further by giving them an outright distribution. Suppose you have a spendthrift. Now, I just read a study on how long it takes a child to spend an inheritance. Guess how long the period is? Well, 3 years. Any other guesses? 6 years. All right, now this is a kind of a vague question because it really depends on multiple facts of your child, how much you have in your estate, lots of issues. This particular study narrowed down the average time it takes a child to spend an inheritance is 17 months. Now, you know your family better than anyone. You know if you have a spendthrift in your family. You know how responsible they are with money. You might have an evil in-law that would help them spend it even faster. I mean, who knows? You know. So what would you do about it? Would you give them a third of your estate outright? No. I don't think so if you're being a good steward. If you're being a good steward of what God's entrusted you with, you wouldn't give it to them outright if you know they would just blow it on wasteful things and not have anything to show for it 17 months later, or 3 years, or 6 years. So what would you do? You would do a stretch distribution. You would have your document, stretch it out over a long period of time. Then you've helped them. I've had people who've actually come in and said, Joe, my son or daughter has not been able to hold a job. They don't have any savings. They continue to find work, but it's paycheck to paycheck. And what I want to do is I want to turn their inheritance from me as their retirement account. So the child has to wait till they are 65 after you're gone to start getting a monthly amount, which consists basically of their retirement account. Have you helped the child more than giving them an outright distribution when they're 30 or 40, where they can still work? Yeah. You've created a retirement account for them. Is that being a good steward of your planning? Yes. And you've kind of forced them to be a good steward because they're only going to get a monthly amount when they turn 65, which serves as their retirement account. You made their inheritance really work. That's a great plan. And if you give it to them outright, it could have just been wasted very quickly. Some of us, including me, have special needs. My brother has special needs. I have a special needs brother. He was brain damaged pretty severely at birth for reasons they don't need. He's 65, reasons they don't even know. Back then it was much harder to figure all this out. My dad was a president of an insurance company and paid for my brother's private care for many years. Sooner or later, the person who owned the private facility my brother was in suggested to my dad, we're selling our facility out, but what I have to do is I have a great facility run by the state in Gainesville, and let me help you get your son in this facility. It's a couple 100 acres, and you have cottages of residents, 12 residents per cottage. They have round-the-clock care on a couple of 100-acre campus. So they eventually got my brother in this facility. He's on Medicaid. Now, my dad is 93. My mom's 93. They've been married 73 years. Got married when they were 20. And they're doing pretty well. They're going through a few health issues, as you can imagine, at 93. And, of course, I did my dad's estate planning documents. And my dad is giving his estate half to me and half actually to the state of Florida for all the wonderful care they've given my brother. Now, if my dad had given half of the estate to my brother, guess what? He would have lost all of his Medicaid government benefits. They would have been immediately suspended. My brother, with the kind of care he needs, would have run through all that money very quickly. Half of my dad's estate would be gone for medical care. And then after he exhausted all of that money, it would have been gone, he'd go back on Medicaid. But he probably would have been kicked out of the facility he's in. So great harm would have actually been done if my dad had given 50% outright to my brother. Now, some of you have children on various levels of government assistance, perhaps. And if you give them an outright inheritance, they could lose their benefits. So have you been a good steward of your money for them? No. Have you helped them? Not really. And a much better way to do it is to plan with what's called a special needs trust or a supplemental needs trust. You'd be a good steward of your assets for their benefit. Suppose they don't spend all of the money in the special needs trust during their lifetime. You have a remainder beneficiary. If they don't use it all, it goes, hey, it could go to your church. It could go to other charities or other family members. But you have a plan for its use that doesn't disrupt government benefits, and you have an ultimate plan for where it goes upon your special needs child's death. Is that being a good steward? Is that being a good parent, thinking of thoughtful considerations in the best interest of your child? Yeah, all of those things are very important. And I think you're charged with the duty to understand. And Pastor, thank you so much for having me come to share some of these thoughts with you. Because if I only help one person and I understand something better they could do better in their estate plan, hey, it's worth it to me. I've spoken to groups of 5 or 10. I had the privilege of speaking at a Sunday morning service at the church at the mall in Lakeland. 3 services with 5,000 people. I do radio every week, and I don't know how many people. I'm on 12 stations now. I was nationally syndicated for a while. Speak to lots of people. So if I can help anybody, I'm willing to do it and take the time to do it. So being thoughtful parents and being big good stewards and being helpful with wise wisdom of things you can do with your money when you're no longer here, I think is a very important thing you've been charged with doing, actually. Now, the third option in estate planning is a living trust. So you can do nothing. We've talked about the pluses and minuses of doing nothing. You can do a will. We've talked about the pluses and minuses of wills. Third option is a living trust. In your little handout I have here, you have a sheet that explains the 3 options in estate planning. It has a little diagram of a trust. A trust is just a fancy will. I had the hardest time explaining what a trust was to a lady today. She just couldn't quite get it, no matter how many times I tried to explain it to her. It was just one of those things like you understand cooking, astrology, sewing, but you don't understand trust for some reason. So you try really hard to explain that it's just a fancy will. You own everything, you control everything. When you die, the trust is still living. The same information I would ask you to create a will is the same information I would ask you to create a trust. If you have a trust and die with assets inside the trust, your home, your bank accounts, your brokerage accounts, and you die, the trust is still living. That's why they call it a living trust. You create it while you're living. When you die, it's still living. Because the assets are in a living trust upon death, they're not in the deceased person's name, and therefore there's no probate. Your successor trustee, whoever it is, maybe one of your children, can come in, pay your bills, deal with creditors, do your taxes, and distribute the estate according to your wishes. And if you want to do a stretch, you'd have to do it in a trust. If you create a trust in your will that does the stretch distribution for whatever reason, you're going to go through probate. Even though your will might call for a trust to be created, that's a testamentary trust. So it still goes through probate to get to this trust if you just have a will. If you have a living trust while you're living and you die, then the trust does not go through probate. And all of these special needs considerations, stretch provisions, spendthrift provisions, all of those can be in a living trust with no probate. So one big advantage of a living trust, just a fancy will, is no probate. The other advantage is it's a private. Your will upon death is a public record. A trust is completely private. So you create a trust, you avoid probate, you name a trustee to be in charge of the trust of your choice. It's a completely private document, not a public record. And, most of us, having two parents are 93, this becomes very obvious to me, even more so than ever, even though I deal with the clients every day that are that old or older and their families. One of these days, I'm going to become incapacitated. I can see that in my parents a little bit. And when I become incapacitated, unable to manage my own affairs, and if I have a living trust, then who I chose as my successor trustee will be in charge of my assets for my benefit and a lifestyle that I'm accustomed with, no guardianship court involved. If you don't have a plan to avoid guardianship, you could be declared incompetent, dragged through a guardianship court. All that's a public record, and it's very costly. If you have a living trust, you have a plan. You have someone to manage your money for your benefit and the lifestyle you're accustomed. You have a durable power of attorney that allows them to make health care decisions for you. You have a plan. And unless you've got everything set up perfectly, then you don't have a plan. One thing I discovered dealing with my parents is that the internist and the heart doctor were really not communicating that well, like they should have been. You find this out when your dad's in the hospital, you find this out. Well, he prescribed this, they didn't communicate, this has an adverse effect, this didn't help any, made it worse. So a healthcare surrogate gets involved in all this, like I did, and you fix it. You get the doctors talking to one another. Right now I have a nurse that comes Monday, Wednesday, Friday. They take my parents. I took my dad to 2 doctor's appointments today. Nurse comes Monday, Wednesday, Friday, spends a couple of hours, takes them all to their doctor's appointments, comes back and checks on them to make sure they're following through on what the doctor told them, because they don't hear very well either. And sometimes they hear what they want to hear, and then they don't do what the doctor says. You know how all that goes. So you need somebody to kind of, and I can't be there every day, and I'm not very medically inclined anyway. I'm legally inclined. I'm not medically inclined. So these doctors don't communicate with one another. I have a great nurse who runs a facility just helping people. But you need to appoint someone to be able to have those powers. And you appoint a power of attorney to do that. And you appoint a healthcare surrogate. Sometimes I combine both of those documents. But a living trust avoids guardianship. It avoids you being declared incompetent. You have someone in charge of your money for your benefit. And a trust is a totally private document. It's not a public record like a will. Now, speaking of wills, a will is a great opportunity to put a personal testimony or statement of faith in your will. What is that? It's a little testimony that you can develop, or I have like 3 sample ones I give people sometimes to choose from. It's a testimony where you state that you believe in Jesus Christ as your Lord and Savior. And you have your own personal little testimony. What's the last thing that your kids or family will read that you wrote and signed? Your will. So you've worked hard, long and hard, and you've worked hoping to be able to see them in heaven one day, and you want them to believe like you believe, and it's been a hard journey. I recognize this in my own family because we struggle with this with some of our family members. The last thing that they will read that you signed was your will. So why not put a little testimony? Why not put a little statement of faith in that will? Why not give it one last shot? When you pass away, that's a big moment in some family member's life. And it's a great time to share once again your testimony with them, hoping they will come around sooner or later. You know what Patrick Henry put in his will? Patrick Henry put in his will, now that I've disposed of all of my assets, in my will, I would like to say this. If that's all they received was these assets, they have nothing. But if they have received the gift of Jesus Christ during my lifetime, or even now, they have everything. Isn't that powerful? Patrick Henry. All right, anybody have a negative reason why maybe they haven't created a trust? You have a negative thought about a trust. You've heard some reason that's kind of delayed you in creating your fancy will or a living trust. Any negative thoughts? Because I'd like for you to share them with the audience and just let me respond to it. Yes.
Revocable and non-revocable. At one time I thought, if I do this, and if I change my mind, I'm out of luck.
All right, I would say I've done, I don't know, I've done close to 48,000 estate plans in my career. 97 or a higher percent of those are revocable. Revocable means you can amend, change, revoke anything, any part of it you want to. So it's flexible. It's just like a will. You can do a codicil to a will at any time. You can change a trust at any time. You can change the trustees. You can change the distribution. You can, Glenn Walker back there, used to work with him a lot in helping clients. It's completely flexible. There's no restrictions on what you can or can't do with your own trust. All right, any other thoughts about a trust and maybe why you haven't created? Yes, ma'am. All right, that is a common thought. So let me explain my fee structure. If you were a married couple and came in and you were headstrong on just doing wills, and we're talking about what wills cost and everything, same information I'd ask you to create a will, same information I would ask you to create a trust. It's just different documents. So 2 wills, or $125 each. Most clients who do wills do durable power of attorney / healthcare surrogates. They're $125 each. And most clients do living wills to say if you're terminal, vegetative, unconscious, end stage, they're $60 each. So the fee for those 6 documents for the will package, we'll call it, is $620. Now if you did a living trust, I would do all of those documents plus the trust, plus deed your house with a quitclaim deed to the trust, and the fee is $795. So you paid $175 more to do a trust package. The benefit of that is no probate, no guardianship, quick, easy, fast, efficient, and private. So the cost of a trust, I've had people come in with $50,000 estates, and I would tell them, well, we can do a will for you, but the minimum fee for a will, probate, a will is $2,500. And there's about $700 in probate costs with the court. And you have to advertise your the fact that you started a probate in the paper, and plus you have to be bonded. With a trust, no advertisement fee, no bonding fee, no probate court fee. And that'd be worthwhile doing the trust right there, not to mention the $2,500 minimum probate fee. So I don't think anybody can argue that trust is too expensive, because it's a great savings to your family not to have to spend a year in court with an attorney and spend all that money, that you could avoid all of that money I just spoke of with a trust. Any other negative? Yes, ma'am. There's no yearly update necessary, and you are the grantor, the creator, and you are the trustee, the manager, so you don't charge yourself a fee and no one else is involved. I send my clients a letter every 3 or 4 years suggesting a review. The review itself doesn't cost anything. If they want to change a trustee or change a beneficiary somehow, there's like a $125 amendment fee to the trust, but it doesn't cost that much to change a trust, really. Any other thoughts about why maybe you haven't created a trust? The other question I get a lot of times in seminars and with clients is, well, once I have a trust, what do I have to do? What happens next? I've got this trust document. What do I do? Well, I would, if I were doing this for you, which I'd be glad to, by the way, if I were doing this for you, I would do a quitclaim deed of your home into the trust. So your home is going to avoid probate because I put it in your trust for you. You would have to go to your bank or your broker and tell them now you have a trust. Hey, Mr. Banker, hey, Mr. Broker, I have a living trust. I want to do just a little simple name change on my account. Instead of the account reading John and Mary Smith, I want it to read John and Mary Smith trustees and the date of the trust. That's what puts it in the trust. That's what makes it avoid probate. Now it's in the trust. So it's not much to do. And if you don't do it, your children are going to have a year of fun with an attorney and the court system. So I don't really know of any other negative things about trust. You own it. You control it. It uses your tax number. You and the trust are the same entity. No extra tax record keeping. It makes it simpler and easier and quicker to administer the trust upon death. And I don't really know of any negative things about a trust. Very, very high. Over 97% of my clients do trusts as opposed to wills. All right. Any other questions about wills or trusts?
I heard you say about putting your real estate in a quick claim deed.
Mm-hmm.
Do you have to fund your trust? Is there a way to put your bank account or other assets or your, how do you do that?
You just go to the bank and tell them you have a trust and just request a name change on the account to your named trustee and the date of the trust.
Okay, thank you.
I'll give you a page of instructions on how to get certain things in the trust, yes.
When it's a married couple, is it actually two trusts or is it one trust? How does that work?
All right, the question is, if you're a married couple, do they do one trust, two trusts? What kind of trust do they do? All right, so here's the answer. If you're a married couple owning everything jointly, say a first marriage or a long-time marriage, you know, and everything jointly, you would do one joint trust. If you are in a second marriage and own assets separately and want to keep them separate, then you have an individual trust to maintain the individual ownership. If you have a taxable estate, how much do you think you can leave tax-free these days? What do you think the number is? It went from 600,000 to $1 million to $1.5 million to $2 million to $3.5 million. 2010 it was unlimited. George Steinbrenner died with a $1 billion baseball team with no estate tax in 2010. But what do you think the number is right now that you can leave tax-free? Any guesses? 6 million. It's $11 million each. If you're a married couple, you get to leave $22 million tax-free. 2011 was $5 million, then it went to 5.2, 5.4. This year they passed it to the Trump administration spearheaded an $11 million exemption for each of you. So 99% of Americans do not have a taxable estate. And now, back when the exemption was 600 or $1 million, there were ways to counter it. Anything you leave to a church or a charity would reduce the size of your taxable estate. So if you had when the exemption was $2 million, if you had $3 million, you could leave $1 million to your church. You'd still have no taxes. I'm not encouraging anyone to play the lotto, but I've had 4 lotto winners in my career so far. 3 of them won 7 and one won $38 million. I got to go to Tallahassee with one of the 7s and the 38 to collect their. I have a picture somewhere of me holding someone else's $38 million check up in Tallahassee. And even if you have a larger estate, there are ways to reduce or eliminate the estate tax. Give it to your church, give it to your charity, create a foundation. There are lots of things you can do to completely eliminate the estate tax with just careful planning. Yes, sir.
As the laws change, you said it will continue to change, you have to update your will every time?
The laws don't change too much on wills and trust. It's basically who you want to put in charge and who you want to give it to. The tax laws change, but most people are not really affected by those. Now, the biggest group that have been affected by tax law changes, back when the exemption was $600,000, I would do what's called an AB trust. So the husband would have a trust, the wife would have a trust. You get at least $600,000 in each trust. You get 2 exemptions. And now that the exemption is so high, a lot of those people are coming back, and we're just doing one joint trust because they don't need the restriction on a separate trust. So something like that was pretty major, but that doesn't come along too often. The durable power of attorney statute changed October 1st of 2011. Power of attorney should be updated about every 3 or 4 years anyway. And so I encourage everyone to sign a new power of attorney, new living will about every 3 or 4 years. You know, I had a client one time ask me, probably after a church presentation like this, they said, Joe, I haven't really tithed like I should have during my life. So I want to know if I give 10% to my church and my will, does that make up for it upon death? Pastor, what do you think the answer to that is? I said, listen, it's great that you want to tithe in your will to your church. God has forgiven you whatever you didn't do in the past, so I think it's a great idea. Let's do it. But, you know, that's an excellent opportunity. You see, you want to support what you've lived, your life, your religion, your belief in Jesus, your church. You want them to continue on their good works that they do. You can certainly leave part of your estate to your church. You can do that with a percentage. You can do it with a dollar amount. You can do that naming them as a beneficiary of a retirement account. That actually making the church a beneficiary of a retirement account is good because there are no income taxes coming out of that money to the church. You leave it to your children, when they take it out, there's going to be an income tax. So if you say 10% to your church and your will or trust, that money would come out of your cash. It's just as easy to name a church a beneficiary on retirement accounts and not have it taxed to the church, and save the cash to give to family members who won't have to pay tax on cash. Your real estate and stocks get a stepped up cost basis upon death, so there's no capital gains tax on those distributions. Real estate gets a stepped up cost basis, which means you bought your house here on the beach for $100,000 30 years ago, and now it's worth $1 million. You die, it's worth $1 million with no tax benefits on it being sold for $1 million. So there are a lot of neat little things you can do in estate planning to be smart planners. And a good estate planning attorney can help you with all of those things, being a good steward. And being a good steward for your family, too, doing what's wise and best for them. Any other questions? Yes, ma'am.
I appreciate the things you just said about the percentages and division and stuff, because before you were talking about, you know, obviously a good illustration, 3 children,
Mm-hmm.
3 ways, that type of thing. But there's pretty much a lot of creativity you can use if some of us have had more interesting lives, and there are more than 3 people in our life, you know, that kind of thing.
Right.
You can kind of divide up however you wish to do. Some can be percentages, some can be amounts.
Well, think about it. If you have 3 children, just to keep that example for a second, and you give each of them a third, that's 33 and a third %. If you gave 10% to your church, the church is going to get 10%, and your kids are going to get 30%. It's not really that much difference between 30 and 33 and a half, and plus you've done something good with your money. You've continued to give after you pass on to something you really believe in that will do good. And also speaks as a testimony of what maybe your children should do in their lives. So you put a little Christian testimony of what you believe in your will and trust, and you give the church some money. You're speaking, you're acting out your faith by what you believe. And the fact they're going to get 3 1/3 % less I haven't seen anybody really adversely act to that. Now, one of the radio stations that carries my program is over in Haines City, Florida, center part of the state. And the church that carries my program owns a radio station. And they are a very, 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 very strict construction-minded church. I've seen bumper stickers on cars over there that go to this church that says, if it ain't King James Bible, it ain't Bible. And I've actually had 1 or 2 people there, because I've spoken to that church a few times. I've had 1 or 2 people come in and disinherit their children because they didn't believe that. Now, I go to Idlewild Baptist Church. My pastor over there certainly doesn't believe that. I went to Indian Rocks Baptist Church for 25 years, and that pastor there certainly didn't believe that. But some churches do. So I certainly respect their belief and their thought. Would never do anything to dishonor that. And that's why I've probably survived in their environment for over 20 years. They've carried my radio program. I go help them with their telethon every year. One time I remember getting ready to go, because we used to have a weekend home over in Haines City, Florida. And once occasionally we would go to church over there. And I remember one time getting ready to leave for church, and I saw my wife wasn't carrying her King James Bible with her. It was another version. I said, put that up. Got to have a King James Bible to go to church today. It's just respecting them, basically, more than anything. All right, any other questions? Yes? If you change residency to another state and if you have a trust, you just do a simple amendment. Say it's governed by the laws of Alabama as opposed to Florida. So what state were you going to move to?
None right now. We moved so many times, and this plans to be the last house we had, but after 17, 18,
Yeah. Your husband has on Alabama colors. That's why I picked that state. All right. Yes, ma'am. Oh, great question. All right. Well, I'm assuming you're talking about real estate. Okay. So if you have a trust, if you have a will and die with multiple ownership of real estate in multiple states, you're going to have multiple probates with multiple attorneys in multiple states. Because real estate is probated wherever it's situated. Yeah. If you have a trust, you can put multiple properties in multiple states into one trust to avoid probate in all the states. If you have a will, then you're going to die with real estate in multiple states and just a deceased person's name, so you're going to have to hire multiple probate attorneys in multiple states to go through probate. If you have a trust, you can get rid of all that. I had a lady one time that had like 30 properties in 30 different states. And we did a trust for her and put all those, I can't do real estate in other states, but we can find attorneys that can help fund the trust with deeds. And so we eventually got all 30 properties in all 30 states in the one trust to avoid probate everywhere. Yeah, real estate is governed by the laws in the state it's located. Any other questions for me? Yes.
If you become incapacitated, is it very difficult to put a governing mechanism in place where successor trustee can change the trust as situations change?
Well, first of all, if you become incapacitated, there's language in the trust that I do that says that two doctors have to determine with written statements that you're incapacitated, unable to manage your affairs. So that's the only way a successor trustee can move up into position to help you while you're living. Usually you don't grant a successor trustee the power to change your distribution language, because soon after you die, your trust gets your revocable trust that you created while you're living, that's revocable as long as you live, becomes irrevocable upon death and cannot be changed. Now, if you have let's say you have a situation where you're uncertain about a certain child, there's other ways to handle this. So if you're uncertain about a certain child and how they're going to react to having money, or they've had issues along the way that would cause you to think that maybe they shouldn't get an outright distribution, you can put language in the trust that this money shall be distributed to them in the sole discretion of the trustee. So effectively, you've made the trust flexible enough to where the trustee can distribute the money to your beneficiary as they see fit, because then they aren't changing the trust, they're just following your instructions of distribution. So that would be the way I would probably handle that one, is I would just put language in the trust of the trustees to distribute money. Now let's say you have a good child, bad child, and you want your good child has been loving, caring, thoughtful, always there for you, always there for birthdays, holidays. Just couldn't ask for a better child. And let's suppose you have a child on the other end of the spectrum that doesn't talk to you, is not respectful, seemingly would care less about what you and what happens to you. So you decide you want to give one child, the good child, we'll call it, their distribution outright. But you want to have some discretion on how the money is distributed to the bad child. So you could do a stretch distribution, or you could put it in charge of the trustee that doles it out in their discretion for the benefit of the child. You can have that share be where the trustee just pays for rent and food and necessities and not money directly to the child, because the child no telling us what the child would do with it. You control what the trustee can pay for the benefit of the child, so they're not become a homeless person basically. There are lots of provisions you can put in a trust to deal with all of those type of issues. And I think you would be being a good steward of managing your affairs if you have a child like that. Don't give them the money outright. Use it for their benefit and well-being and health and education and medical and everything, but have the payments made by the trustee directly to places that are going to help them, as opposed to them giving them money outright, which no telling what they might do with it. Any other questions for me? Yes, sir. Mm-hmm.
So it would know what that is. In a trust, is that total amount of the estate available to whomever is dispersed to?
Yeah, usually the beneficiaries, unless it's just a dollar amount, if it's a 50-50 distribution, they are entitled to an accounting of the assets and how you determine their 50%. If you gave them, a couple $100,000 off the top, and the rest to be held for a bad child in the sole discretion of the trustee, then they're not really entitled to an accounting, because you gave them a dollar amount off the top and the balance to the other child. The most interesting question in that little scenario is who becomes the trustee? Because you never appoint the good child who receives his half outright to be the trustee for the bad child who gets their money over time. It's like, I've got my money, but I'm managing your money, and you're only getting this. So you always have a kind of an independent trustee for the bad child's portion of the distribution.
Historically, is that someone like a bank officer? Or?
It could be in a bank, or it could be a bank with a trust department, could be a CPA, could be an attorney. I'm a trustee sometimes on distribution. One of my favorite distributions of where I'm the trustee, a lady came in with no children, no family. She had about $2 million. She wanted to create, went to a Catholic church, and she was of Catholic faith. We talked and talked about what she wanted to do with her money. She really loved young people and wanted to provide scholarships for people who couldn't afford to go to college. So we created this 20-year trust after she died. She died about 5 years ago. She named me the trustee. She wanted to, she had $2 million, so it's $100,000 a year I get to distribute out to Catholic high school graduates for their first year of college. So we have $5,000 the first semester. If they have a B average, they get $5,000 for their second semester. CCC, Catholic high school, selects the students. They have some competition program they set up and give me a list of names, so we help about 20 students a year through their first year of college. I get the most wonderful letters from these students of what that meant to them and how it changed their life. I have another one that I'll just share with you, that April the 16th of this year, I get to fly. I'm leaving out Monday night, coming back at noon on Tuesday, but I get to go present a $1 million check to St. Jude's Hospital in Memphis. And they're part of the PGA. It was part of a PGA. The person who died was a golf professional. And so they're making a big PGA event out of this and making a presentation. I think it'll be televised in June sometime on television at something that St. Jude's Hospital is involved in on a golf distribution. Whenever I get to give money to a church, I like to personally deliver the check because it's really good for a person to give money and to be a helpful cause. And it needs a little special recognition that they did that, because that serves as a great example to other people, I think, in their giving. Pastor, yes, ma'am.
Can I give a personal testimony? I moved here 6 years ago, didn't have an attorney. I listened to 570 AM, and Mr. Pippin's on the radio every Saturday morning. And I thought, he makes a lot of sense, you know. I think we should try him for what we need down here now that we live in Florida. All his fees are online. And guess what? That's what you get charged. I mean, you know, you never know about attorneys. They have a bad reputation. And we've been very happy with his services for the 6 years we've been here, and I just wanted to give you a personal testimony.
Well, thank you so much. All right, I'm going to turn it back over to Pastor. Thank you so much for having me tonight. I love doing this. If you have a group of any type that needs a speaker, I love going out to do this. I love doing my radio show. I could be playing golf Saturday morning. I'd rather go help people on my radio show. So I love doing this, and thank you so much. And Pastor, thank you for having me.
Have you learned something tonight? Yeah, I know that you have, and thank you, Joe, for coming. I know that you could be a lot of other places as well tonight, but it's really important to us to handle what God has blessed us with in a way that would glorify Him, and I think that taking these provisions now is really, really important. So one of the things that I find so honorable is that Mr. Pippin has agreed to come without any expectation that you would use his services. That's honorable. But I will tell you that I have, as I said, about 25 years ago, had the chance to use Mr. Pippin, and we just believe that you can't do any better. You may have a family friend that you want to use, and that's fine. There's no expectation here. He's not taking names. We didn't furnish the list to him, but I would encourage you, wherever you do it, do something and do it quickly. That's really, really important. And any questions that didn't get asked, anything at all that you want to ask that you just now thought of that didn't get asked?
By the way, this coming Saturday's program, I replayed my Trial of Jesus program. So it's like the 3 Roman trials, the 6 Jewish trials, the trial before the people, the laws back then versus the laws today. I did this with Judge Harry Fogel about 20 years ago, and I'll replay it almost every Easter.
Wow. And that's on 570 at 8 o'clock. So great. Anything else? Father, thank you for your time. The time we have had tonight. Thank you for raising up people who can give us wisdom and insight, and that wisdom and insight built upon and based upon solid biblical advice. Thank you for that. And going forward, may we be good stewards, and we'll thank you for that. We will thank you for that in Jesus' name. Amen. Amen. God bless you. Make sure that you say personally thank you to Joe, and talk to you later.
Conquer.